In eSwatini, of course, 2 siblings have been arrested in relation with the killing of AKA and Tibz. That proceeding in the Manzini Magistrates Court is now underway. Let's listen in.
South Africa.
Your Lordship, the applicant will no longer pursue that application, Your Lordship. For reasons that will be given by Marlene and friend, Your Lordship. That is all, Your Lordship.
As the court pleases. My Lord, with respect, my Lord, we still insist that we are opposed to the application that has been made by the Crown, my Lord. But maybe before I proceed to that point, my Lord, I must indicate that it is correct that we did receive the affidavit, which was intended to accompany the application for detention from the Crown, Your Lordship. Yes. Now, my Lord, to us it would seem as if, my Lord, the cart is pulling the horse, yet in actual fact the horse should be pulling the cart. This is the reason, my Lord, with respect.
Leli hash kanti kufanele ukuthi kube hash ledosa lenqomo.
Yes, my Lord, if His Lordship would respectively pay attention to the precise contents of the request. The Crown, my Lord, is requesting detention of the exhibits, handing over to the requesting state, which is the SABC, my Lord. Yes. Now, my Lord, with respect, our submission is we are being placed in an invidious situation, or rather a position, my Lord, because, my Lord, it would be immaterial for us to make or take a position now prior to having received the comprehensive application for extradition, my Lord. Reason being, after receipt of that application, my Lord, that is when we will be able to sit with our clients to take full instructions, my lord, inclusive of the application for detention of the cell phones. Now, it would defeat the whole logic and or purpose, my lord, why we would be dealing with this application now instead of dealing with the application simultaneously with that for extradition. So the submission is quite simple, my lord. We are of the view that the application for detention is premature because it is specific that it's for subsequent handover to the SAPS, my lord, with respect. Therefore, my lord, having said that, we are highly opposed to the application for detention. To the best of my recollection, this court had actually issued an interim order for provisional detention the last time we were in court. We would humbly apply that that rule be extended, my lord, as opposed to granting a final and definitive order for detention, my lord.
Ngekubuka kwakhena ubuka kungazuthi lenzaba yalesicelo lesendiwa ukuthi kugcineke lamazibithi lawa ngeke ukuthi bafuna ukuthi bese bawamikisa kulamaphoyisa ase-South Africa kungathi ke kuyinto levele ngesikhathi lesingasiso ngoba bona batawukhona ukuthi bakhone kuphendula kuko konke lokhu nasesekufikile lesicelo lesibuya kulamaphoyisa ase-South Africa bese bayakhona ukuthi baphendule sebaphendulela konke. Nyalo inkantolo beyikhiphile sijubo zokuthi ke letinciko leta iqhubeke igcineke ngemaphoyisa angacela ukuthi kuqhuthekwe kuleso sijubo sokuqhutshekselwe phambili.
Yes, and my lord, with respect, may the court also take into account that that the status quo prevailing currently, there is no prejudice that is being suffered or that will be suffered by the Crown in the event this honorable court does not grant a final and definitive order for detention, my lord.
Uphinde futhi kude lapho umshushisi atawukhinyabeteka khona nangabe le inkantolo ingasikhiphi isinqumo sekugcina ke kule ndzaba le yalokuthi kugcineke lamazibithi.
Yes, my lord, fortunately, my learned friend made a submission before this honorable court that they were still within time. Which buttresses further the point that there's no prejudice to be suffered pending receipt of the full and comprehensive application for extradition, my lord. We will holistically deal with both applications after having had the privilege to then take full instructions after having been served with the application which is pending service before this honorable court, my lord.
Sekude kinyabeteka lokutaba khona ke batawukhona ke ukuthi bakwende konke kanye kanye nasesekukwendiwa nasekufike nale maphepha lalenzelwe ukuthi ke afike batawuse sebayakhona ukuthi baphendule konke sebakhona ukuthi bayimisele ke nabo umsomo.
And for the record, my lord, we intend to even instruct counsel for the actual application, which will also require further consultation and instruction on how and in what manner to proceed, my lord. So the long and short of it, my lord, is we are opposed to the application for detention. May we kindly be furnished with a comprehensive application for us to take full instructions, and we shall accordingly revert to the Crown and the court, my lord, as to our position moving forward.
Sike loqhubeka ke kwaleli cala basatawufuna ukuthi baqasheke labanye ke labantu abasita ngokuthi-ke vele-ke bayaphikisana nalesicelo esendiwe-ke ngomshushisi-ke phambi kwenkantolo bona batawubuya batokwenda lokhu nokuthi nana naye nasetamcasha sawufuna naye ukuthi-ke athole ukuthi-ke afunze lawo maphepha akhone ukuthi naye atinike isikhathi bese-ke sebayakhona-ke kubuya-ke batewuphendula konke sekukanyekanye.
Yes, my lord. I cannot take the matter any further, my lord.
Your Lordship, Your Lordship, on the issue of prejudice, Your Lordship, there is nothing my learned friend has advanced before this honorable court showing that the granting of a final order, Your Lordship. By granting the final order, Your Lordship, the respondent will suffer any prejudice. That is strike law, Your Lordship, that if an application is opposed on the basis of prejudice, they must advance the reasons why they say they will suffer prejudice. Otherwise, it is normal when you apply or when you seize items from a suspect, they are detained.
Yes, he's saying a provisional order is not made final. The applicant will observe a prejudice. That is what he's saying.
Your Lordship, our problem is that these cell phones do not form part of the request, the extradition request. These are items that it's a matter on its own. The extradition request will come with the contents, whether there is a prima facie case or not, as per the extradition law, Lordship. That dictates that if there is an application that has been made, the requesting state must indicate in the request that there is a prima facie case upon which the respondent will be required to answer in his home country, or Lordship. This is not part. These cell phones do not form part of the extradition request, Your Lordship. And I don't know how my learned friend is marrying the two.
Seke umshushisi-ke lokhu ingqinamba lenkulu ukuthi-ke kule application noma kule sicelo lesitamu le ndzaba yale tincingo ayikho yona, akukhulunywa ngayo ngoba yona le ndzaba lesicelo lesitamu sitabe sichaza ingcikitsi ukuthi yini imbambambamba-ke lokwenta ukuthi vele kuthiwe ababuye batewumelana nemacala abo.
So,
Yes.
by necessary implications, you are saying the cell phones will not be used by the application, that's by the applicants during the hearing in substantiating the application. Is that what you are saying?
That is actually what we are saying. We are saying this.
Not relying upon.
We are not relying on the cell phones for the purposes of the application, Your Lordship. These cell phones, Your Lordship, if there is anything that is relevant to the case, will be used in South Africa, Your Lordship, during trial. This is not trial yet.
Uthi-ke lama cellphone-ke ngeke asetshenziswe kule ndzaba lena. Lama cellphone nangabe kukhona lokutawutholakala kuwo kungasetshenziswa laselitekwa-ke le eSouth Africa nyalo kusengakacali ukutekwa lecala.
The only duty for this honorable court, Your Lordship, is to determine, upon perusal of the application, Your Lordship, whether the content shows that there is a prima facie case against the respondent, Your Lordship, upon which they are required to answer in their home country, Your Lordship.
Sike umsebenzi wale nkantolo kusike ibuke ukuthi ngabe vele naseyibuke lamaphepha ukhona yini lokufakazi lokuvetayo ukuthi vele kuyadzinga ukuthi bahanjiswe bayele event labo ukuthi ke bayophendulela le kulokukhulunywa ngakho.
That is all, Your Lordship. In short, Your Lordship, we indicated that we are abandoning the issue of the release of the cell phones to South African police, Your Lordship, today. That will be pursued in the near future.
Bayahoxisa-ke lokho ukuthi letincingo-ke bathathe thatha bayotiniketa-ke emaphoyisa ase-South Africa kulosuku lwanamuhla. Lokho sekuyawondiwa ngayolunye lusuku.
So now, just on this one.
Yes.
Now, he is saying there's nothing suffered by the prosecution or the applicants in this case, when the provisional order not to be enforced as a final order.
Your Lordship, he has not substantiated that position, Your Lordship. We applied for the final detention order. He is opposing it. He is the one who must tell the court what prejudice he will suffer, because we are acting in terms of the law, Your Lordship, that this exhibit be detained pending the granting of the request, Your Lordship, before this honorable court. Otherwise, if the court grants this application today, Lordship, there is nothing that the respondent will suffer when we adhere to the law, Lordship. That's all.
Yes, I want to give you a chance because things here are by Mr. Ndimande.
Yes.
Saying cell phones will not form part of this application. So, what do you say?
Yes. Thank you, my lord. My lord, with respect, for the coffee better word, my lord, the proposition by my learned friend, to say the least, we are of the view that it is quite absurd. This is the reason, my lord. My learned friend is basically, I'd say, giving evidence from the bar. What he is doing, he is preempting what ought to be in the application, which application is not before this honorable court. In short, he is telling this court that he is aware of the contents of the application, yet we are still not aware of the contents of those arguments, in that application.
I object to that. That is not the correct position. I haven't said so.
But my lord, if his lordship, my lord, with respect, if his lordship could take the submission in contents, my learned friend is preempting the contents that will be contained in the application for extradition. He has just made a submission before this honorable court to say the cell phones will not form part of the extradition application. However, my lord, the question then becomes, how does the applicant know that, because we are not the requesting state? The requesting state is the Republic of South Africa. They've been making submissions to say they're waiting for an application from the Republic of South Africa. How is it then possible now, my lord, before court to know the contents contained therein and whether or not the cell phones will be involved or not, my lord? That is the first question. The second leg, my lord, with respect is... Yes, the court, please.
umshushisi nakethathe kulotake uthi le kule application letako ngeke kube khona ke letindzaba talama cellphone ke khona uyabuta ke ummeli ukuthi kungasi umshushisi so utfula bufakazi yena ukuthi ngathi so uyati ukuthi kule application letako kuyini lokubhaliwe khona ngoba nawo so uyasho ukuthi ama cellphone angeke abe khona kanti phela leyo application itabe ichamuka kulaba base South Africa njengebantu bacela bomhlola ukuthi babuyisele eveni labo so kwathi ngani ke yena lo
Yes. Can I proceed, my lord? Thank you, my lord. And then, my lord, the second leg is, my lord, this honorable court, specifically this court, my lord, is known to be the bearer of justice and not injustices. How, my lord? We need to always maintain the principle of ode alteram partem principle, my lord. We do need to take full instructions. That's the principle of fair hearing, my lord. We cannot run the risk. I am standing here as a representative. I work on instructions. I cannot take decisions in the absence of full and further instructions, my lord, being furnished to myself or our offices, my lord, as the legal representative. So that principle of ode alteram partem should not be jeopardized, my lord, because, my lord, already the court has given us a quasi-remedy to say we have a provisional detention order, my lord, which means the status quo prevailing will still be maintained with respect, my lord. There will be no prejudice, because that's the main question, my lord. What prejudice is the applicant going to suffer in the existence of the provisional detention order? The question is none, my lord. Then we come to the second leg of my learned friend's submission to say, no, we have then elected to abandon the detention of the cell phones for onward transmission to the Republic of South Africa. Then this very same question still exists, my lord. Then what prejudice are they going to suffer? Because now they've abandoned the application and the cell phones are currently in their possession, my lord, through that provisional order, my lord.
So ummeli kude kukhinyabeteka labantu nako ke umshushisi nangabe ke ngesicelo lesi singaselo ukuqhubeka lesi lebe sikase inkantolo isikhiphile evikini leliphelile ngokuthi lesekugcina singede sakhishwa lamuhla ngoba kude lapho batawukhinyabeteka khona ngoba phela nako umshushisi ube sesuyaveda newe ukuthi sebayasixoxisa ke lesi celo sokuthi ke batabe sebayahamba nama cellphones bayawanika ke lamaphoyisa ase-South Africa. Loko solokumile ke lokho ukuthi ke yini ke lokutabe sekusikhinyabedo nyawo nangabe lokho ukuthi ke digcino ke sikhashana ke emaphoyiseni inkantolo ikukhiphile kude lapho khona bona batawukhinyabeteka khona.
Yes. Yes, my Lord, it is our humble submission and or prayer, my Lord, that the provisional detention be extended to the next date, or rather, my Lord, for the record, until receipt of the application for extradition to allow us to take full and further instructions, inclusive of whether or not we will change our stance in terms of the detention application, my Lord, because we need to take full instructions, my Lord. That is what the order alteram pater principle dictates, my Lord. I cannot take it any further, my Lord, except that we are highly opposed to the application and that provisional detention may it be humbly extended, my Lord, as there will be no prejudice to be suffered by the applicant.
Wenda sicelo ke sekuthi ke le order ke yesikhashana lebeyikhishwe ke inkantolo kayichitshekiswe yona phambili ngokuthi ke vele bayaphikisana ngokuthi ke lesicelo lesi sale sikhishwa ke le order yokugcina ngokuthi ke futhi ke bona bacela ukuthi ke kubuye kutokhulunywa ngayo nase seyitholakele ke lamaphepha la kabuya ke eSouth Africa kuze kuthi nabo batokhona ukuthi bathole isithuba sekuthi bakhulume ke nabo umsolwa betenga.
Yes, now Mr. Just one issue.
That's the court, please.
No, what exactly is it that will be taken away the right to be here, to be made in full? Now, what is it that will be taken away from what you intended to say in the court during the hearing? If the cell phones are detained.
Well, my Lord,
There's nothing, there's no interference with them because they are sealed. They are always there, but detained because now the detention is not a permanent matter. At some point in time, further applications will be moved touching on the detention.
As the court pleases, my Lord, I appreciate his lordship question, my Lord. My Lord, this is the risk that we need to run away from. We do not know the contents of the actual application for extradition. That's the starting point, my Lord. Secondly, my Lord, whatever contents are contained therein, we do not know what bearing they have in the information contained or rather obtained from these cell phones, my Lord. Now, there is an issue, a key issue that requires us to take full instruction to be able to deal with, by way of analogy, my Lord, just by way of analogy, not to say I'm placing it on record per se. What if my clients are keen, or rather, what if procedure dictates that we be furnished with what is contained in the cell phones and what really they were seeking to achieve with the cell phones? Just to make an example, Your Worship, by way of analogy. So, but then the long and short of it, my Lord, is may we please be allowed this extension so that we take full instructions and the manner in which they were detained. It will all go down into the next phase or hearing for arguments on this particular issue, my Lord, because now we would have had full instructions from our client. Because as it stands, my Lord, we do not have comprehensive instructions, mainly because we don't have the comprehensive application, my Lord. Now, the gist, rather, my Lord, what I'd love the court to appreciate is the issue of prejudice, either on the side of the applicants or on the side of the respondents, my Lord, has been remedied by the court issuing a provisional, which we are all saying, may it kindly be extended, my Lord, because the status quo will be maintained at the end of the day. Yes, my Lord. That is the key application. We can have the provisional detention extended. We've got no objection to that, except the final and definitive order, my Lord.
the applicants stand up now? Now, applicants, the gist of the matter is that there is still no formal application from the Western State for the case to be heard.
Solo manje ke kuseteke baphepha yaqhamuka kule live licela ukuthi ke nimikiswe kilo lata ucela ukuthi ke nimikiswe khona.
So it has been agreed between both sides that the matter returns on the 20th of March, pending receipt of those documents.
Uvunyelwe nje ukuthi ke nitawufike nibuye ke phambi kwenkantolo ngomhla ka-20 ku-March noma nasekutholakele ke lawo maphepha.
Now there's also this matter regarding detention of the cell phones that assist yourselves.
Kwenzeke kube lana indzaba le ukuthi ke lama-cellphone lakatholakala kini-ke ukuthi funa ukuthi agcinelwe ngalokusemthethweni.
When the matter was last before court, this court had made a provisional detention of the cell phones.
Nayivela ke le ndzaba ke le inkantolo ke yakhipha ke i-order ke yesikhashana.
Now, today, the applicant's representative has applied that order be made final or be confirmed.
Namuhla ke nasekuvelwa ke umshushisi ke wende isicelo sokuthi leyo order leyo sale igcizelela ukuthi sengiyo mina.
Now, your attorney has objected or opposed that request by the prosecution.
Ummeli wenu ke usiphikisile ke leso sicelo ke lesenziwa ngumshushisi.
Now, he's not in a position to substantiate much on the objection.
Kuhle ke lokhu kanani lakakuvetile ke ngale kuphikisa kwakhe.
Now, what the court accepts is that he still has to look at the papers. That is the main application to be brought by the requesting state before he can take instructions of you.
Sikela ka uvuma ukuthi ke usafuna ke abone ke lamaphepha latawuqhamuka kule live letocela nini ukuthi nimikiswe kilo bese ke soyakhona ukusakhulumisane nani bese ke soyakhona ukubuya tophendula phambi kwenkantolo.
Now that has been countered by Mr. Ndimande, who said that the main application will have no bearing on the detention application, because after all, these cell phones will not be used in the extradition application.
Kuvetile ke nemshushisi ke lokho ukuthi ke lama-cellphone ke ngeke abe khona ke kule ndzaba yalo noma kule sicelo ke saloko ukuthi ke nimikiswe kule live labomakhelwane.
The necessary implication is saying he has other sufficient evidence for purposes of this application besides the cell phones.
Kusho ukuthi ke banabo lobunye ke bufakazi le banabo ke ngaphandle kwalobu lokuthi bangakuthola ke kulama-cellphone.
Now, the court has taken into account that there is not much to be suffered by both sides when the cell phones will be detained.
Bonile ukuthi kude lokungakanani lokungaphinde beteka kubo tonke inhlangothi nangabe lama incingo tingakwazi ukugcineka.
But the court has taken into account as well that in as much as the cell phones will not be used in this extradition application, the cell phones are interlinked to the extradition case, directly or indirectly.
Sike noma ke kude lokungakanani ke lokutawusetshenziswa ngala ma-cellphone kulezicelo sokuthi ke nihambe nibuyele ke evenileni kepha ke futhi ke lama-cellphone wona
Now, this is because the extradition application is linked itself to the intended criminal trial in the requesting state. So the cell phones themselves are interlinked to the criminal trial in the requesting state. I say that because it has been hinted to this court that there was an intention on the part of the applicants to move an application for release of the cell phones to the requesting state. So now, perhaps, even though at this stage there is no prejudice that has been shown by the respondent's attorney on why the detention order currently existing should be made final, there is perhaps a reason for the attorney to fear some form of prejudice, even though saying it is not being disclosed. So now the court will, in a way, allow the objection for us to await the receipt of the formal application for the respondent's attorneys to go through it, to take instructions and see whether or not the final detention can be opposed. The court is going to maintain the provisional order that is made pending final determination of these applications for detention and the main application.
92 counts more. The reduction were from burglary.
All right, what a pity there. Looks like our connection to the Manzini Magistrates Court, that's where that case is currently unfolding, has somewhat been disturbed. But I think the gist of the matter has now been captured. The case being postponed to the 20th of March. A big part of the contestation was around these cell phones that SAPS here at home want to keep in the lead up to the extradition of these two suspects. That connection is a bit more stable now. Let's take you back and listen in.
The main application
as the business regime. The court is going to continue with its other cases.
So live visuals once again coming out of the Manzini Magistrates Court. As we went back there, it seems they had reached the tail end of proceedings. So there you have it, postponed once again by a week, this time to the 20th of March. And this is all because the South African government is yet to complete their extradition application. You might remember at beginning of the proceedings we're waiting to hear on two main things. The one was around whether or not South Africa had finally made that extradition application. The second was around whether or not the Manzini Magistrates Court will allow this request from the SAPS to send through, or rather to keep the cell phones of these two suspects as part of the main evidence, if you like, once the trial finally gets underway here at home, with 7 suspects in total. On the one, we hear that that application hasn't been made yet, and that by and large is why we're seeing another postponement to the 20th of March. And then it appears that there still hasn't been a final decision around these cell phones and whether or not they should be kept. Those who are representing the suspects, I should say the defense, arguing that there may be prejudice if these cell phone records are kept in a context where we don't know whether or not, in fact, this will form part of the extradition application. On the other hand, of course, the SAPS being represented in that court saying that this is presumptive to assume that this, in fact, wouldn't be part of the evidence once that extradition is finally submitted, the application at the very least. We'll definitely be watching how it all unfolds for you in the Manzini Magistrates Court to get you a sense of what the way forward looks like in a context where, let's face it, there have been already so many delays at the early start of this particular trial. So stick around on SABC News. Ntantla Jele, part of our team inside the eSwatini Magistrates Court.